Good afternoon. This is our continuation of our Board of Commissioners meeting for Tuesday, November 12th, and it's now 1:30 p.m. We're moving on through our agenda. We have items 10A, 10B, 11A, 12A, 13A, B, and C, 14, 15, 16. We do have an executive session. We do have a time certain at 3:30. And we have, I think, county administration legal counsel announcements. Okay, so at this time I'll read our agenda item 10A, public hearing order 19-11-12-09 in the matter of the surrender of a portion of 19th Street, County Road numbers 667 and 1141, and a portion of Yolanda Avenue, County Road number 840 to the City of Springfield with the public hearing. We'll be at some point hearing from Mr. Jay Blomay, our Lane County surveyor, and we'll ask you to make a presentation. Then we'll open the public hearing. Then we will close the public hearing. Then we will discuss the order and have a motion to approve the order. So welcome, Mr. Blomay.
Thank you, Chair Sorensen. Good afternoon, Commissioners. We are here today for the board to consider surrendering jurisdiction of portions of 19th Street and Yolanda Avenue to the City of Springfield and to hold a public hearing for public comment on this matter. The City of Springfield, pursuant to resolution number 2019-19, attached as Exhibit B to this order, has requested that these roads be transferred from Lane County to the City of Springfield. A public hearing and posting is required for this matter per ORS 373.270. This matter was posted along both roads on October 18th, which included the time and date of this public hearing and my contact information. To date, my office has received one phone call from a citizen who wanted additional information regarding how the surrender, if approved, would affect them. The surrender of these roads is the final action of an intergovernmental agreement between Lane County and the City of Springfield that was authorized in 2015. The IGA facilitated improvements to both county and city facilities as part of a preservation project. The IGA required that the city annex the subject roads into the city limits and request jurisdiction be transferred to the City of Springfield's control. The annexation was approved by the City Council in 2018. The section of 19th Street proposed to be surrendered is approximately 0.39 miles in length and is located between a point just southerly of Bonnie Lane and the intersection of Yolanda Avenue to the north. The section of Yolanda Avenue proposed to be surrendered is approximately 0.25 miles in length and is located between its intersection with 19th Street and the westerly right-of-way line of 23rd Street, as depicted on the vicinity map attached as Exhibit E to this order. The Public Works Director and Public Works staff support surrendering jurisdiction of these roads to the city. Surrendering jurisdiction of the roads will allow the city to manage the roads as they see fit and will relieve Lane County of the obligation for future maintenance and improvement expenditures. At this time, I will turn this matter over to you for additional questions prior to opening the public hearing.
Okay, are there any questions from commissioners before we have the public hearing? And then I'll call on Commissioner Burney to make the motion once we do the hearing. Any questions before we do the hearing? Okay, so at this time I will open the public hearing on order 19-11-12-09. There's no one signed up to testify. Is there anyone present who has not signed up to testify that wishes to testify at this public hearing today on the surrender of a portion of Yolanda Avenue? Seeing no one that wishes to testify at this time, I will close the public hearing. Call on Commissioner Joe Burney to make a motion to approve the order as presented.
Thank you, Mr. Chair. I would like to move approval of order 19-11-12-09 to surrender a portion of 19th Street, County Road number 667 and 1141, and a portion of Yolanda Avenue, County Road number 840, to the city of Springfield.
Okay, it's been moved by Commissioner Bernie, seconded by Commissioner Bozievich to approve the order as presented and previously read. Further discussion? Seeing none, we'll go to a vote. All those in favor, please say aye.
Aye.
Opposed, say no. And the order is adopted unanimously by the Board of Commissioners. Thank you so much, Mr. Blomay.
Thank you.
Thanks for making life easier for us, as you always do. Thank you. Okay, next we're calling up our folks that are here on the item 10B, so you guys can get set up while I read this. Let's see, today's winner in the lengthy board title agenda, category is today's 10B. Second reading and public hearing on ordinance number PA 1376 in the matter of amending the Lane County Rural Comprehensive Plan, RCP, to add a new quarry site to the Lane County inventory of significant mineral and aggregate sites to authorize mining and processing pursuant to Oregon Administrative Rule, OAR 660-023-01802, redesignate land from Forest F to Natural Resource Mineral, NR:M, QM, and to require site review pursuant to Lane Code 16.2574A through J, and adopting savings and severability clauses, file number 509PA 18-05008. And with us to discuss this important yet riveting matter is Rachel Surslev, Lane County Planner, and Ann Davies, Lane Council of Governments Principal Attorney. We've set this up for a 15-minute presentation, Ms. Surslev, and if you could introduce the topic and tell us what we should be doing.
Certainly. Thank you, Chair, and good afternoon, Commissioners. This item before you today is a privately initiated Rural Comprehensive Plan Amendment and Zone Change. The subject property is Rattlesnake Quarry, which is an existing ODOT owned and operated quarry located southwest of Cottage Grove. The quarry is located in both Lane and Douglas counties, but this proposal only applies to land under Lane County's jurisdiction. The subject property is identified as map number 210414, tax lot 1100, and a portion of map 210400, tax lot 200. Before I provide the full staff report, I'd like to introduce Ann Davies, Principal Attorney with Lane Council of Governments. Ann's been assisting Land Management Division in processing these applications, given the large number of them, and she has assisted in the review of this application and will be available for questions. The board held a first reading on October 29th, 2019, and scheduled this hearing for today. Since the first reading, staff has received comments from the applicant themselves, requesting a change to 2 of the conditions of approval, and copies of these comments have been provided to you today. The existing quarry site is split between Lane and Douglas counties, as I said, with approximately 24 acres in Douglas County and 58 acres, including the proposed expansion area in Lane County. Currently, the quarry contains areas for excavation, stockpiling, and processing. The Douglas County portion of the site is used for processing and stockpiling, and the Lane County portion is primarily used for excavation. And I've got a vicinity map up here showing where the subject properties are relative to Cottage Grove and Interstate 5. And actually, I'm gonna have this one up first. Well, we'll go back to this one. So this is a site plan of the existing operation showing the land that's in both Douglas County and Lane County. It shows not very well that most of the excavation is happening on the Lane County portion of the site, while the stockpiling and processing is occurring on the Douglas County side. The aerial photo gives us a little bit better idea of what the existing operation looks like. We have the existing excavation occurring primarily on tax lot 1100 to the north, and then it does cross that boundary between tax lot 1100 and 200. So there is a bit of excavation on that northern part of tax lot 200. And the remaining portion of tax lot 200 that's involved in the application is undeveloped area that's mostly forested. And the applicant is seeking to add this entire 58-acre area to the inventory of significant mineral and aggregate sites, and to rezone and redesignate this entire 58-acre area. So the proposal can be broken down into 5 individual requests that are evaluated in the staff agenda cover memo. Briefly, the request is to add the site to the Lane County inventory of significant mineral and aggregate sites and allow processing and mining per Goal 5 administrative rule. And that's OAR 660-023-0180. And that OAR is applied directly to the proposal because the criteria for authorizing mining is not adopted directly in Lane Code. Further, the site will be redesignated and rezoned to natural resource mineral and to quarry and mine operations, respectively, to be consistent with the proposed use. And lastly, the QM zone requires that the proposed development be evaluated with the site review standards that are located in Lane Code. And this is just a depiction of what the existing plan designation and zoning is of the subject property, and then what the proposed zoning is going to look like. So some application history. The application was submitted in January of last year and first went to the Planning Commission in February of this year. At that time, the application proposed to add the entire 58-acre site to in Lane County to the mineral and aggregate inventory, but only to redesignate and rezone tax lot 1100. The Planning Commission found that adding the area to the inventory, but not redesignating and rezoning that same area for mining and processing was inconsistent with Lane County's comprehensive plan. Therefore, the Planning Commission recommended denial, and as a result, the applicant revised the proposal to include rezoning and redesignating that entire 58-acre area instead of just the single tax lot 1100 to the north. And at the August 20th, 2019 Planning Commission deliberations, the Commission motioned to recommend approval of the application to the Board of Commissioners. So moving on to the Planning Commission recommended conditions of approval. Through evaluation of the relevant approval criteria, the Planning Commission found that the proposal met all criteria and identified 7 conditions of approval to meet that approval criteria. And those conditions are embedded in the findings of fact and are provided as Exhibit 7 of the agenda cover memo. Since completion of that memo, the applicant has commented with revisions to condition of approval 2 and 3, which I have up on the slide. Staff would like to note that the Planning Commission did spend a notable amount of time working on these conditions of approval to make sure that they complied with the actual approval criteria. But I think staff is in support of the changes that the applicant is proposing. One, because there's email correspondence attached to the memo that the applicant submitted, showing that they've had correspondence with Lane County Transportation Planning, which showed support for a one-time vegetation removal. That's in regards to condition of approval number 2. And then staff feel that the change to condition of approval number 3 is really just a clarifying change. So I think we would be in support of altering those conditions if the board felt that was necessary. And additionally, staff wanted to point out an error in the findings of fact relating to conditions 6 and 7. These conditions were linked to a finding that they were linked to the incorrect finding. So we would like to alter the findings of fact to make sure that those conditions of approval are actually coming from the correct approval criteria. So To conclude, the Planning Commission found that all criteria have been adequately satisfied and recommends approval of the application with the 7 conditions that are outlined in the agenda cover memo. However, staff recommends that the board requests that staff modify the findings and ordinance to make the changes to the conditions that I just discussed. And that concludes staff's presentation, and Ann and I are available to answer any questions.
Okay, would you like to have the board ask questions before we start going into procedural rules for the hearing?
It's up to you.
Okay. Do any commissioners have any questions for staff before we go into the procedural rules for holding the hearing? Commissioner Bozievich.
I just have one question, because it's hard to tell from maps. Is this in the Willamette watershed or the Umpqua watershed? It looks like it might actually be Umpqua.
I would have to double check.
It looks like it's right on the border.
Yeah, the only reason I ask that is it does change the criteria for significant when it comes to the volume of rock. Not that, if you meet the Willamette, though, you meet Umpqua.
I think it was Willamette, but I can double check what watershed we noticed.
Okay.
That might answer that question.
Okay, any other questions? Okay, so at this time, I'm going to start reading the procedural rules for holding this hearing. And so this decision is subject to the Goal 5 Administrative Rule, OER 660.023-180, and Plan Amendment and Rezoning criteria cited in the agenda cover memo and attachments, and evidence and testimony must be directed toward the approval criteria or criteria believed to apply to the decision. And this hearing is subject to the county's procedure for a de novo quasi-judicial public hearing found at Lane Code 14-070. And the order of proceedings for this hearing will be first to hear from staff, which we've already done, followed by applicant's testimony, followed by persons who are in favor, followed by testimony of other persons and additional comments by staff, and then applicant's rebuttal. And the failure to raise an issue with sufficient specificity to enable a response may preclude an appeal to the Land Use Board of Appeals. And prior to the conclusion of the public hearing, any participant may request that the record be left open to provide an opportunity to present additional written evidence or arguments regarding the application, and the board's decision may be appealed to the Land Use Board of Appeals in accordance with ORS 197. So this is the opportunity for those present to enter information into the record. Only persons who qualify as a party may appeal the board's decision to the Land Use Board of Appeals. At this time, I will call on disclosure of board member ex-party contacts and abstentions due to conflicts of interest, ex-party contacts, or biases. Are there any? Okay, I have polled the board, and none of the board members have any ex-party contacts. Is there anyone present that wants to challenge the board's authority to hear qualifications to hear this matter? I have seen no such request to enter a challenge in the record. So at this time, I will open the public hearing on this item and ask if there's anyone signed up for this public hearing. No. So there's no one signed up for this public hearing. Is there anyone present who has not signed up for a public hearing but wishes to now enter testimony into the record of the Board of Commissioners? I see no testimony. Is that correct? Yes.
I know the applicant wants to testify, I believe.
Okay.
I'm not sure when she'll do that.
All right. Well, why don't we have the applicant come forward, because we have already had our staff presentation, so we will move on now to the applicant's testimony. So would you like to come forward? Just come on up and sit by Ms. Davies here. Welcome. We do bite. We do not bite. Okay.
Leave any marks?
If you could introduce yourself and take maybe a few minutes to tell us your testimony.
Sure. Good afternoon.
Oh, and pull your microphone closer.
Is it on? Okay, there we go.
Yep.
Good afternoon, Chairman, members of the board. My name is Virginia Eland, and I'm the applicant representing the Oregon Department of Transportation in the interest of Rattlesnake Quarry, a publicly owned rock source. So I just wanted to thank staff for working with us on this application. It's been a long time coming, and it's a lot of information to sift through, and they've done an excellent job in helping us determine how we meet the criteria for this unique quarry, which sits on both Douglas and Lane County line and has been in operation since the 50s. So we've reviewed staff's report and support the recommendation of approval with clarification of conditions 2 and 3 as presented to provide additional clarity, since these conditions will be attached to this application for many years to come. And I'd be happy to answer any questions you have about what you've read or heard or seen.
It looks like it's in the Umpqua watershed. Is that accurate?
So to answer, I'm sorry, I can't.
Commissioner Bozevich.
Bozevich, thank you. I didn't want to say it incorrectly. So the criteria for whether or not it's in the Willamette or Umpqua, I think it's defined by the soil shed, and they do that to determine the amount of rock is needed and in regards to whether it's in farm forest area. So this is in the Willamette Valley, but it's very close, and I think I'd submitted something in our early application in support of that, and it's more tied to soils, so wineries, things of that nature. So it's not a watershed, it's a soil shed.
Okay, very good. Okay, would you like to add anything else before we thank you for your testimony?
Again, this has been a difficult application, and it's been a good learning experience, so
Okay, thanks so much.
thank you.
Okay, so I have not seen anybody that wants to testify, but once again, I'll ask, is there anyone here that wants to testify? Seeing no one, we will move on. And there isn't a request to continue the hearing, is there? No? Okay. So at this time, we will close the public hearing, and we will turn to the board for discussion and possible action by the Board of Commissioners. Is there any commissioner that wishes to be recognized? Your district, want to be recognized?
I personally don't see anything that pops out as an issue for me. So with the criteria, it's my understanding that it would, what you're looking for today is a approval of this, and with the criteria number 2 and 3 as presented, right?
Yeah, so it'll have to come back for a third reading in order to change those conditions of approval to change it to what the applicant is requesting. And then there was also a minor fix that we wanted to make in the findings.
Okay. So I can make the motion? So we-
Yeah, what is the date you want to propose?
I did not have one in mind.
At least 2 weeks out.
Probably 2 weeks out. Are we meeting 2 weeks from today?
No, it's
That's
Thanksgiving.
Thanksgiving.
Okay, some of you are, but I am not.
The earliest would be December 3rd.
They're down.
Want to do December 3? Yes?
Yeah, that works.
Okay. So, Commissioner, you can make your motion with that information.
Okay, I'll move approval of the second reading and public hearing on ordinance number PA 1376 with the criteria number 2 and 3, as well as some corrections that you've identified. Do you need me to change that?
Condition to it.
Condition 2 and 3, and some clerical changes that you identified. And move this to the December 3rd Commissioner meeting at 1:30.
So can I just ask for a clarification? When you say approve the public hearing, did you mean to close the
Yes, I
public
did.
hearing and close the record?
Thank you very much.
Second.
So it's been moved to move this item to a decision by the board on December 3, as mentioned in the motion that Commissioner Buck made and seconded by Commissioner Bozievich. Any further discussion or clarification on the motion? Okay, seeing none, we'll go to a vote. All those in favor, please say aye.
Aye.
Opposed, say no. Order is adopted unanimously by the board, or the motion is adopted unanimously by the Board of Commissioners. Thank you. Thank you. See you on December 3. Okay, Mr. Mokrehysky, I'm looking for some guidance from you. Do you want us to move into 12A, the lien matter, or do you want to do the commissioner business?
We can do, I know Keir Miller is here, so we could take up 12A. Does Sebastian need to be here? I think Andy was going to check to see if Sebastian could come.
You want to have us do the commissioner business while we wait
We could
for?
take that up if
Yeah.
you wanted to, yeah.
Okay, so we'll do what we can on commissioner business, number 13. And when Sebastian gets here, we'll suspend and go back to the item on 11A. So at this time, I will call on commissioners under item 13A. Any announcements any commissioners want to make? Commissioner Burney? Or you're exercising? One of the two.
I normally don't do this, but I would like to just share with the board that Maddie and I had our third grandchild.
Hey!
Yeah, yay. And
Why wouldn't you share that with us?
well, normally I stick to business. But Emmett Rossum Blair was born at just over 6 pounds on November 11th, and they're going to keep coming. And I would also just very quickly like to share that Thursday is going to be a touching day for me. I will be making a presentation. Joining me for her first day will be the young intern that I've selected. She's a graduate of Springfield High School and is a U of O student and lives in Springfield. And the poor thing, our agenda for that day, she won't make the MLK Commons groundbreaking, but will be a city club meeting, a meeting with the Springfield Education Foundation, an El Rapa board meeting, and an opening of an ambulance company that's opening at 42nd and Main in Springfield. And in addition, will be a young man who's also a graduate from Springfield High School who I mentored 25 years ago for 2 years. And he is now the swing ship supervisor at Far West Steel. He has a wife and 2 children. For those of you, like I know Commissioner Farr is very knowledgeable of Springfield. His wife's family are the owners of the Busy Bee Cafe. And this young man was headed to prison. And when he found out I was running for commissioner, he texted me for the first time in 25 years. And well, he couldn't text then, for the first time ever, and said, thank you for taking an interest 25 years ago in a broken young man. So a 44-year-old, a 20-year-old, the Springfield community, and I just wanted to share that that'll be a touching day for everyone. So thank you for that, Mr. Chair.
Okay, any other announcements under 13A? Go ahead.
Just want to note that this week, my internet radio show will be on a special date and time. It'll be on Thursday at 4 o'clock instead of Wednesday, because I'm going to have a guest. I will have Stephen Sheehan of Elkhorn Brewery as my guest. And of course, people know that he's got the Eugene Wake Up movement going right now. So we'll be talking about probably a lot of homeless issues on Thursday afternoon, and particularly right after the groundbreaking of MLK. So it'll be an interesting radio program Thursday at 4.
Very good. Any other commissioner announcements? Go ahead, Commissioner.
I just
Buck.
want to put out a reminder that I'm going to have my open office hours in Cottage Grove on Monday, the 18th, from 10, right after the Beeper Show. I'll wander over to City Hall and be there till about 1:30, and if anybody wants to attend, they can. I'd be happy to see them.
Very good. Any other commissioner announcements? Commissioner Farr.
Thank you. A couple of things. You all nodded your heads that I would be on the DUI Impact panel, and we have our first meeting on Thursday of this week, tomorrow, at noon tomorrow, just before the Homes for Good meeting. Second thing I'm going to mention is a document that I pulled off of our website today that I'll read. It's called the Eugene Springfield Lane County Homeless Service System. So I'll read a little bit from the introduction of it. It's, the homeless service system is a collection of both short-term and permanent housing options, along with supported social services available to individuals, families, and youth experiencing homelessness in the Eugene Springfield Lane County area. Nonprofit agencies, government agencies, and faith-based organizations partner to provide these crucial community services. The homeless service system helps people experiencing homelessness get connected to stable housing, increase skills and income, and move towards self-sufficiency. Maybe, I have a hunch that folks haven't taken a look at this. But if you look at it, it's out of date, it needs to be updated, and we need to make it a little bit more robust. But it's got the listing of emergency shelters in the local area. It's got the listing of access centers and community service centers. It talks about specialized permanent housing, rapid rehousing listing. Transitional housing is listed, permanent housing, permanent supportive housing is listed. This is all on our website under Human Services. So it's some of the things that we were asking for this morning regarding what are we doing. We already have the document in place, and I think we can spend a little bit more time making it up to date, Mr. Mokrasky, and making it include maybe a few of the things that aren't listed on here. But this is, once again, on Lane County's website under Human Services, and it's called Eugene Springfield Lane County Homeless Service System, and it's a collection of both short-term and long-term permanent housing options, to include some shelter. So, thank you.
Good. Okay, so this time I'll call up item 12A, and we'll have Kira Miller and Sebastian Tapia come up. This is 12A, discussion request for the forgiveness of a lien in favor of Lane County Land Management Division attached to the property located at 82855 North Platte Road, Cresswell, Oregon. Our presenters today are Kira Miller, Land Management Division Manager, and Sebastian Tapia, Assistant County Counsel. We set this up for a presentation of 10 minutes and a board discussion of 20 minutes. So welcome.
Thank you, Chair Sorensen. Good afternoon, Commissioners. So Sebastian and I are here to talk about a rather unusual issue and request that's been made to the board involving the property located at 82855 North Butte Road in Cresswell. It's within the Cresswell urban growth boundary, just adjacent to the city limits of Cresswell. It sits at the base of Cresswell Butte. So there has been a long history of Land Management Division code enforcement action against this property going back to the mid-2000s. This has included 3 separate code enforcement cases. It's involved a considerable amount of staff time and coordination over the years. The most recent code enforcement action against this property was initiated back in 2013. As a result of that case, the county was able to assess a lien against the property in the amount of, fines against the property in the amount of $21,900. That lien continues to this day, and it accumulates, and as of this morning, the amount stands at $34,880. The land use violations on this property have included expired building and electrical permits, a failing septic system, and an enormous amount of solid waste and waste on the property. There's also, as the board heard today during public testimony from the current owner and prospective buyers, there's been a long history of sheriff's office involvement with this property. There's been a number of criminal activities alleged there, including drug use, at least 1 drug overdose, and a number of theft issues related to this property. So it really has been a blight on the neighborhood and an eyesore in the community of Cresswell for some time. In 2015, Nation Star Mortgage Company successfully foreclosed on the property. As part of that foreclosure process, Mr. Tapia did some wrangling with the attorney for Nation Star and determined, was able to assert that the county's lien had priority over the bank's mortgage, and as a result, our lien survived the foreclosure process. The property was subsequently sold at a sheriff's auction in March of 2017 by Mr. William Spencer, who again the board heard from this morning, and he has provided some requests and information to the board in writing, which is included as an attachment to your packet. Then following his purchase in 2017, our understanding is that he was interested in selling the property to two individuals who were then going to work on the property, clean it up, and then sell it or flip the property after it had been restored and cleaned up. In the course of attempting to sell the property, those prospective buyers conducted a title report, and they found out that the lien was still in effect. And at that point, Mr. Spencer, as well as the potential buyers, contacted the Land Management Division and County Council and asked that this lien be forgiven. That's not something that we have within our ability to just forgive this lien owed to the county, and it wouldn't be in keeping with past practice. As the staff report mentions, we've kind of researched this issue of possible lien forgiveness, and it's not something we've ever done in the past that I've been able to find out about. There's definitely been some recent cases of where, previous public works director actually denied a request for lien forgiveness. Now, granted, those situations aren't exactly like this one. This is a fairly unusual situation where you have an individual in the community who, by his accounts, purchased this property with the intent of just rehabilitating it for the betterment of the community and not necessarily to make a profit on. So it's obviously a policy choice for the board whether or not the board is interested in forgiving this lien. Is the staff report again suggests the Land Management Division and County Council don't recommend lien forgiveness just because of the potential equity issues concerned, and that, when the property was up for auction, other potential buyers could have purchased this property but may have chose not to because they had done the research and found out that there was a lien against the property. Again, it's there is a financial impact to the Land Management Division. Our code compliance program really operates on a pretty thin budget. We have 2 FTE, 2 full-time code compliance officers for the entire county, and we're also trying to ramp up a lot of our abatement efforts to, correct these nuisance properties. And any funding that would be realized through this lien would be put back into that abatement fund, and it could be used to the benefit of other properties, to clean up other properties around the county. That being said, we do recognize that this is a unique situation and that Mr. Spencer has cleaned up the property according to the information he's provided the board. He's invested in not just the initial $72,000, which he paid for the property, but an additional $12,000 just cleaning up the garbage to date. And there's other outstanding expenses that would need to be undertaken to remedy the expired building and electrical permits. The staff report tries to provide some brief analysis, although this wasn't really an in-depth part of the staff report. We try to provide some analysis of what the property potential worth might be, and we recognize that is, those records, the tax assessor's records and online property sales records don't necessarily account for the actual site conditions. We know this house is very distressed. That being said, the property has a number of potential selling points. It's an acre in size. It's immediately adjacent to the city of Cresswell's urban growth boundary. Current zoning would allow a second dwelling on the property, an accessory dwelling unit. I've spoken with city staff at Cresswell, and they indicate that the city would welcome this property to be annexed into the city, which surrounding properties are all about 0.15 acres in size. So it's potential that this property could be divided into as many as 4 additional lots. Mr. Spencer also owns the adjacent 4 acres immediately surrounding this property, which are primarily vacant land. So the city also indicated that Mr. Spencer's been in a number of times to talk about the potential subdivision of all that property. So I think he's aware of the possible development opportunities with this property. But again, I recognize that he has incurred costs and it has been to the benefit of the community. But regardless, based on past practice and our concern about setting a precedent to forgive a lien amount rather, And for the equity issue stated, staff still recommends that the board choose not to forgive this loan. If the board is interested in forgiving the loan, there are additional options available to you, which are discussed in the staff report. These include the partial forgiveness of the loan or forgiving the loan up into the so in other words, forgiving the loan to the amount of the original principal at the time the property was sold, which was $21,900, and forgiving the accumulated balance on that. So there's different options that the board can discuss there. I think, unless there are questions, that completes my remarks.
Okay, so do any commissioners have any questions? Commissioner Buck?
This property happens to be in my district, and I had a couple of conversations with both staff and Mr. Spencer. I have one particular question, which is, if the county has a lien of their own on a property in which we're putting up for sale through this foreclosure process, is that not disclosed during that sale process? You would think if it's our own, we know about it. At the very least, that information could be provided. I understand that other liens that are not Lane County related would need to go through title, and it could potentially be a clouded title at that point. It just seems more logical if the lien was our own, that would be presented up front in the sale.
Commissioner Buck, good afternoon. Is this on?
Yeah.
This is Sebastian Tapia with Lane County Council. If the difficulty is that this was not Lane County's foreclosure, this was a bank's foreclosure, and it is sold as is and with all faults. In terms of additional disclosures that the sheriff's office might be able to do, in theory it could, it really isn't their position to do so. It was a bank's foreclosure, the sheriff's office acting as an administrative agent who's required to do the sheriff's sale. So in terms of disclosing liens that the county owns on behalf, and using the sheriff as our agent, is just not how sheriff sales are working.
I can understand that. That's a good point that you bring up regarding the bank foreclosure versus our own foreclosure. I still feel like there might be some point to the fact that if we're the facilitator to that, is there not a way to be able to disclose our own liens in a more open and transparent way?
It could be, but again, we would be interfering in another entity's process. This is the bank's foreclosure, and for us to step in and advise and possibly talk people out of purchasing could be perceived as not a benefit, but as a hindrance to the entity that's selling the property.
Commissioner Bozis, do you want to ask a question?
Yeah, thank you. So, Sebastian, the act of foreclosure, what does that technically mean for, the bank when they go through the court process of foreclosure? What does it mean for the bank? What does it mean for the folks that are named as defendants?
The holder of the deed of trust initiates a complaint asserting priority over all other lien holders. For the most part, a bank will foreclose its own interests as well as its attorney's costs and the costs of foreclosing the property. There's typically not excess to junior lien holders. For the purposes of Lane County's benefit, I've negotiated maybe a half dozen, maybe more, instances in which a bank asserts a priority over our own lien, and I educate them that they are subordinate to our own. So in that limited circumstance, someone like Lane County, whose interest came after the deed of trust occurred, was actually superior to their own. There aren't a whole lot of other exceptions for which a later initiated lien has superiority over the bank's lien. So to answer your question, for the most part, the bank gets paid from the proceeds of the sale. For the most part, any junior lien holders don't get anything, with the exception of Lane County. In our instance, we were dismissed from the complaint, meaning that our lien survived.
Yeah, so as I read the notice of the sheriff's sale, and if I was an attorney even reading it, it lists the fact that, that by virtue of this decision on part of the mortgage company, it names and lists a bunch of people from Consolidated Credit Services, Jefferson Capital Systems, Occupancy Property, and Lane County as defendants in the foreclosure. It does not list that Lane County was dismissed from that suit. Reading that notice of sale, my presumption would be that Lane County's interest in this property was foreclosed upon, which means it is no longer valid. I mean, am I reading that notice wrong?
I apologize, Commissioner Bozovich, I don't have the specific knowledge about a bank foreclosure to the level that you're asking. However, what I can point out is that Lane County Circuit Court records are public records, and somebody doing due diligence in the purchase of a distressed property would have every motivation to look up the information for free at the second floor in the circuit court and see exactly what the order of default pertains to. They would very readily available, the documents are readily available to instruct that person that a lien survived the process. I think that falls in the category of due diligence in the purchase of a distressed property.
Yeah, I think, though, when you're talking about something put at auction and you don't know if you're going to be a successful bidder on it, I think that's a large expectation. I think there's nothing in the notice, though, that would lead somebody to believe that they weren't foreclosed out of their interest. And that's sort of what I'm getting at. This is more to Commissioner Buck's point, somehow or another, we need to make sure this process at least has some kind of notification that we requested to be dismissed and were successfully dismissed. And I don't know whether that's a change in an ORS, that needs to be part of the notification on a bank foreclosure, or what we need to do going forward. But I can see this being a consistent problem if we're going to start asking to be dismissed, but our sheriff's sale notification doesn't note that, but it does note us as a defendant in a foreclosure. The presumption is we no longer have an interest. If I'm reading this notice of sale, that's what I get out of it.
I understand your concern, Commissioner Bozovich. Lane County government has nothing to do with the preparation of those advisements. Those come from the bank, and it's the bank's interest. Lane County Sheriff's Office is acting purely as an administrative agent pursuant to that order.
Yeah, then I think, maybe that's why I'm saying it could be a legislative necessity that fixes that. Whether we work through Alex to get a little change in statute to where if there is somebody dismissed, they're not listed in the sheriff's sale as being part of the foreclosure. That's kind of, there just was, if I was somebody bidding on a piece of foreclosed property, one, I don't know if I'm going to be successful, so I'm not going to pay a title company for a title report. And a lot of times foreclosures are happening fast enough when they come up for sheriff's sale that there really isn't time to get a full title report. I think the expectation there is a little bit tough for us to be beyond. I think, now that's come to light, and it wasn't until the property owner wanted to sell it, not as part of his adjacent, but sell it to somebody else. So this has nothing to do with the adjacent property. I think that's kind of, somebody else is taking it, and at that time, those buyers ran a title report because that was a typical exchange of property between, two private entities, and our lien shows up. I am leaning towards, because of, one, why the property was purchased, two, the fines were never really used for on-site abatement. And I have a little bit of difficulty with the fact that he's actually the one that's paid the abatement costs, yet the fines were intended originally to be utilized for us to do that work, and we did not do that work. And I'm a little surprised sometimes that banks are giving up on these foreclosures as easily as they are against us because we haven't actually done work on the property. Right now, it's a fine that's for prospective abatement, not an actual, recovery of an abatement cost. Which I think if the banks understood that, they might not be so quick to dismiss us from the foreclosure. So I'm leaning towards some kind of relief in this situation, and that's just my personal gut feeling.
Commissioner Bozievich, if I may just respond to one of your observations in terms of timeliness. Again, I don't do bank foreclosure, so it is outside of my expertise. However, what I do know is the bank can go through one of two routes. One is a non-judicial foreclosure, and the one is a judicial foreclosure. We've been talking about judicial foreclosures. Judicial foreclosures are always slower. To give you a context, the non-judicial foreclosure takes 120 days. So I don't know how long a prospective bidder might need, but I wouldn't agree that it's a fast process.
I'm not talking about the foreclosure process as much as I'm talking about the sale process. The actual time it was advertised for sheriff's sale to the actual bid on the property, that's the time period I'm talking about. The person that purchased the property, wouldn't even know it was up for sale until it was noticed for sheriff's sale. He wasn't participating in he wasn't a party in the foreclosure, wasn't involved in the foreclosure. We advertised it for sheriff's sale. The community notified him and said, could you please buy this property and help us out? So he submitted a bid for the property. That's the time period I'm talking about. And I think that time period from notice of sale and actual bid is not a very long time period.
And again, I'm not familiar with that process.
It's not months, let's put it that way.
Understood.
Let me ask you a question. Do we have authority to forgive a lien in favor of Lane County?
Commissioner Sorensen, Mr. Miller asked me to research the same question. I looked through lane manual, lane code, statutes, and charters, and found a general absence of authority or restriction. The closest thing I found in Lane Charter, Chapter 2, Section 5, General Grant of Powers reads, and I quote, "Except as this chapter provides to the contrary, the county shall have authority over matters of county concern to the full extent granted or allowed by the law of the United States and of the state of Oregon."
Okay, well, I was wondering if I could get my tax lien lifted after we do this one. I don't know if we have authority to do that, but.
The tax lien is a specific statute and completely different from the conversation we're having today.
And I don't see any other commissioners that want to bring that up. Okay, so Commissioner Burney either was exercising or requesting to speak.
I know.
You mentioned it.
I know. Do you have any sense of, I find this actually murkier than I anticipated. And I have been approached with, advocacy for Mr. Spencer's request. Do you actually know the time frame between when the auction was announced and when the sale occurred? Because
I'm not familiar with that process.
How much time one had, right?
I apologize. That's something that I could have had prepared today if I had realized that that was the scope of what the board was asking about. I apologize. I don't have that information.
No apology needed, but you can see how that would be relevant. what is the interest rate that the county charges on liens of this nature, or this specific lien? Because obviously, it's accumulating. It equals well over 50% of the actual lien at this moment.
Right. It looks like the current rates of accumulation are about $260 a month, or about $8.60 a day.
Is it possible to break that into an interest rate?
About 9%.
The reason it got murkier for me is because you mentioned that there's already been discussions, but I don't want to get involved in individual private person's transactions, but here we are. So you already mentioned that and I see you're here, so that Mr. Spencer, this might fit into a larger development plan. Is that what you were implying with your remarks?
I'm not entirely sure what Mr. Spencer's plans are. I will say
But you
I had
brought
conversations
something
with the planners in the city of Cresswell, and they've indicated that Mr. Spencer has been inquiring as to the developability of the properties that he owns in that area, and he owns the subject property and a surrounding immediately contiguous 4-acre parcel as well.
Well, I can tell you, I share where I'm leaning, and I'd like you to tell me if that's incorrect or things I should consider as I'm leaning in that direction, which is forgiveness of all interest and not forgiveness of the lien. But I want to hear what other commissioners have to say. I find that, and part of the murky part for me is the time frame, because Mr. Spencer, you seem as if you obviously know more than me about the community of Cresswell, what you're doing there, with the community's growth. I love Cresswell, by the way, sincerely. And I find it hard to understand not researching liens on a property, that's all. But maybe there wasn't time, or maybe it was just an oversight, and that's why it's bounced back to this body. So that's what I'm wrestling with, and that's what my tendency is to want to do.
Okay, so do any other commissioners want to ask or say anything? Go ahead, Commissioner.
I may have later, just a
Adfar.
couple of procedural questions. Thank you, Mr. Chair. So the initial lien was 21-9, and it was issued in June 24th, 2014. Now, what was that $21,900? What would that be used for?
So this,
If that lien was paid that day, that moment, what would that $21,900 have been used for?
that funding would go back into the Land Management Division Code Enforcement Program. And again, I wanted to clarify one of the comments that Commissioner Bozovich made, in that funding isn't specifically earmarked for an abatement program. It's an administrative civil penalty that's more of a, it's a method to achieve compliance on a property. So fines are assessed until a property comes into compliance, or often they just get to such a level that the homeowner just walks away, and then the property changes hands, and then eventually it's cleaned up. So that funding, to answer your question, would go directly into the Land Management Division Code Enforcement Program.
Fund someplace.
It's not a general fund.
A fund that would pay other bills. So the $21,900, how was that amount determined? What scale do you use to determine that amount?
In Lane Code Chapter 5, there is a administrative civil penalty process, and there's a formula based in that section of code that kind of spells out the nature of the offense, the reoccurrence, whether it's for financial gain or not, and there's a number of different factors that go into calculating a daily fine that can be assessed. So it depends on the scope of the infraction, the duration of the infraction. There's a number of different variables in that formula.
But it typically comes back to a specific infraction or list of infractions.
It stems from, a specific.
You say waste accumulation, et cetera. Okay. That's all the question I have for right now. I'll listen to more further discussion.
Okay, any other questions, comments from commissioners? Commissioner Buck.
As I hear about the administrative procedure that takes place during this process. I get a little more irritated that we're unable to be more transparent in this process. It feels like sometimes these liens are played in a way in which you're kind of hiding. It feels hidden for the purchaser that's going up and trying to buy these foreclosures after the fact. When I don't find why that's necessary. Now, it may mean that we could follow up on a legislative change if there's enough support for something like that. It just doesn't feel right when we, of course, as the facilitator of these things, know our own liens and lien amounts, and we're not able to present it with the rest of the material because it's a different process for a bank. And I could go into bank foreclosures, but that's a whole nother ball of wax, and we don't really have any direct oversight on that. Having said that, I understand that there's clear formulas written in our code about what these administrative fines should be. That's been out in the open for quite some time. The work that Mr. Spencer has done on this property, the community couldn't be happier. The county couldn't do what he could do. And if we need to create some kind of policy or language in our body to address that kind of situation and these kinds of liens, maybe we should think about doing that. Since I know that the lien original amount of $21,900 is in our body and in our code and has been for quite some time, I would like to make a motion that we direct staff to forgive the accumulated interest portion of that lien.
Okay, is there, there's a motion by Commissioner Buck to forgive the interest on the lien in the property involved here. Is there a second?
Well, I'll second it for purposes of discussion and vote.
Okay, so it's been moved by Commissioner Buck and seconded by Commissioner Burney to forgive the lien on property, lien that Lane County owns on property located at 82855 North Butte Road, Crestwell, Oregon. Quick question, do we have authority to forgive this lien?
Chair Sorensen, I believe that the county has inherent authority under the Lane County Charter. However, I can't point to a code provision or a manual provision that would directly apply.
Okay. And do we have other liens that we have put on property that other people could come in and ask that those liens be forgiven as well? So we could debate each one of those separately as well?
I think it's very common that subsequent purchasers have asked us for forgiveness, to be forgiven for previous owners' liens. So yes, I think it's common. I think it has happened before. I think it will happen in the future.
Okay. How many do we have now if we wanted to forgive all of them rather than just one?
I would say in the last 2 years, I've had about 6 or so bank foreclosures for which I was successful in convincing the bank not to foreclose on our lien.
Okay, very good. Commissioner Bozovich.
So I want to dig down a little bit on what is in the 21,900, because I'm familiar with a lot of current enforcement actions in my district. Quite often, that's an original violation fine, and then there's basically some per-day fines that go on, and then once that builds up, then there's actually, up to the point of sale, there was also interest involved. So it kind of, I want to try and clarify, when we're talking about forgiving the interest since the date of sale, that's not really forgiving all the interest. What was the, can we dig down to what was the original principle of the fine? No interest.
I'm sure we could. I apologize. I don't have that information in front of me right now, but I assume it's available.
Yeah, I have a feeling that, there's quite a bit of interest in that 21,900. Yeah, that's, I just want to make the board aware that interest doesn't start at time of foreclosure. The interest had been building up to the foreclosure because the way our system works. We charge initial fine, that administrative fine, and it starts building interest.
And that's his principal amount?
Yeah, yeah. That's what I wanted to try and clarify. That 21,900 is not the principal amount. If you want to try and forgive interest, there's interest that was actually building prior to the foreclosure act, and the sale, I should say. Foreclosure actually happened prior to the sale. Time-wise, I can answer some of that question because it's on the sheriff's notice. It's in our file. The original advertisement of the sheriff's sale, if I can, sorry, I had it up here and now I lost it, was like May 2nd or in April, and then the actual sale was like May 18th. Darn it, I must have scrolled down past it now.
Now I'm looking for it.
I had it and I lost it. But it was several weeks. The question is when did the actual buyer find out about the sale? Because the advertisements are in newspapers in their legal notice column. So yeah, it might have been advertised in April, but the actual, from the time the buyer found out about it and was asked to purchase it to the actual sale. So that's kind of, I guess if I was in the profession of buying foreclosed properties, I might be perusing the legal notices all the time, and if I have one interesting, maybe have time to run a title report and invest the money in a title report. But based on something I might not be able to buy. So it just, the answer's there in the documents. I'm sorry, I'm just not finding it right now, but it just, down at the bottom of the sheriff's notice, it has the advertisement dates there in the Register Guard. But just, if there's no other desire to go lower than the 21.9, I'll vote yes on this motion. But I really believe, one, that we're stepping in and basically asserting an interest that supersedes a bank's initial mortgage. And I'm concerned that we're doing it on something that wasn't actual abatement. This is a different issue in some ways, and maybe one I'll have to have discussions with legal counsel about later. But one of the ways you can put a big halt on residential mortgage lending in Lane County is for banks to start thinking that we have the ability as a county to assess an administrative fine and then take priority over a first mortgage document, deed of trust. Just think about that for a few minutes, how chilling that could be in our, housing market if we continue to do that. So that's a separate issue we'll have to deal with later. So I'm a little concerned that we're being successful in not being foreclosed upon, based on the fact that staff has said this is purely an administrative fine. Why would a bank loan hundreds of thousands of dollars on a property if we can come in for tens of thousands of dollars in administrative fines and take priority? So that's sort of, and be forgiven from the foreclosure process. So it just, separate subject we'll have to discuss more later, that I'm a little concerned about. But I really would like to get down either to the real basis of the original fines, and then, and not charge any interest at all. But I'll support the motion as is, just to try and provide some relief, because I think this was a case of somebody trying to do something really important and well for a community, and then being caught by something that any normal person reading that notice would have thought we were foreclosed out of that right. You know, that's, you know, and we need to fix that notice. It's statutorily, whatever we do.
Go ahead.
It's getting less murky for me. First off, I absolutely support forgiving the interest on the debt, and I support ending interest on the debt, so that there's at least that level of certainty moving forward. I also support what Commissioner Bozovich said about finding out what the actual amount was, because I naively read principal amount of $21,900, and I think that's the amount of the liens, and they may be, I'm learning, they may be far less than that. Whatever they are, I want this body to know I'm all for forgiving everything other than the original lien amount, which we may find comes to a very small, a relative smaller amount of money. I want to thank you, sir, for what you've done for the county and the community of Cresswell, because that's not what we're talking about, but that undergirds everything. I want to share that some communities I've developed in actually offer incentives for private property owners to do exactly what Mr. Spencer has done. And I also want to mention that in my previous work, Jay's right again. Whenever, I don't know if the implications would be to cease mortgage lending in Lane County. That to me sounds a little dramatic. However, banks need, any private interest needs certainty, and certainty includes not allowing liens which occurred after the first was made to take priority over the first. That's just not good business practices, and yet I also know accumulated tax liens and other things that are attached to property do in fact supersede firsts. So I mean, that to me is not like a big surprise. So again, I support the motion. I support finding out what the actual amount was for the liens, and I support reducing Mr. Spencer's obligation to the county all the way down to the bare bone amount of the fines that were originally imposed on that property for abatement.
Commissioner Farr.
Thank you. And I have a couple of quick questions for you, Sebastian. Commissioner Berney, does your addendum, does that imply that is wrapped into the motion, that you're the maker of the motion, you're the seconder of the motion, that an investigation of the actual original fine amount be conducted, and that we
If the maker would agree, the second one.
Yes, I was going to addend, so
Okay,
please do.
then my questions are based on that. Mr. Tapia, you said that you have maybe 6 or so other similar kinds of loans, liens that are in some form, some stage of the process. Can I assume from that statement that every one of them is exactly like this, that the lien, that the person actually making the purchase from the sheriff through the sale would not know that there's a Lane County lien unless they had done some form of diligence prior to making the bid on the property? Or these are the 5 or 6 or however many, is it implicit someplace in there that there is already a lien, that they knew there was a lien on it when they made the bid?
Commissioner Farr, Lane County doesn't do the advisements. That's the bank's responsibility. So what the prospective purchaser knows depends on the diligence of the prospective purchaser. I'll also point out that our lien is recorded, and that through deeds and records, a person can enter in the property address of any property, especially a property they intend to purchase, without paying for a title search, and see that there is a lien, and also see that it hasn't been extinguished.
I think I understood that. So you don't know what the buyers knew prior to actually making the bid on the sale. And when they made the bid, they didn't know if they were going to win the bid also, correct?
I think that's correct, Commissioner Farr, and I do have to qualify that I don't follow that process. When Lane County foreclosed on its own lien, we did appropriate advisements because we were the plaintiff. In this case, we are a lien holder that survived the foreclosure, and we really aren't in a position to make advisements.
I understand. So okay, I understand. So we all heard this morning the fast turnaround that Mr. Spencer had upon hearing about the property, and the deadline for the bid and the sale sounded like overnight, basically. So there would have been no time in that type of a situation for any kind of a search? Or are you saying that somebody could have gone online and just punched a button and found that there was a lien?
Commissioner Farr, I can go to Deeds and Records and punch in the information and get it within minutes. I can go up to Circuit Court and type in the case number, which would be referenced in the foreclosure, and see exactly who has been defaulted or not in minutes.
Somebody who does this for a living, or does it as a job, would understand and know that, but somebody who just is acting out of the, the goodness of their heart based upon the plea of the citizens of the community that they live in.
I'm not a savvy real estate investor, but I would suspect that folks who are savvy in real estate would know some free tools that are available through the county.
All right. Well, thank you very much. I'm inclined to vote yes on your motion, Commissioner Buck, and I may pay a little bit more attention to it. I think we have a little bit of an issue here, because the first thing that Commissioner Buck talked about was I think maybe the word used was transparency, but the evident nature of how we are doing business. And this was clearly, as Commissioner Bozovich noted, it's not in the statement of sale, or it's not evident in the statement of sale. Making things easier to read, easier to understand is probably something that we should pay attention to. And if it is legislative, then let's make it legislative. If it's not, then let's just make it a matter of policy that we let people know if we are going to be asking them for more money when they buy a piece of property. It seems to me just a good way to conduct our business, that we aren't saying, oh, by the way, you owe money, when people really had no way of knowing ahead of time unless it had gone through what the process that you described, Mr. Tapia. So I'm inclined to vote yes on the motion, but I'm also anxious to hear what the original fine amount was. Thank you.
Do you know how much money the lien is? In other words, it was principal and interest, or principal and statutory interest. Do you know the amount of the lien, or would that be determined if the board approves it and you come back with an amount?
Chair Sorensen, what we do know right now is that the initial fines against the property were $1,000 a day until such time as it was recorded, and that's the document I think we need to obtain to find out what the actual principal was at the time it took effect. And then, and that's information that if it was worked into an order, we could probably determine that information and come back with an order that, if it was worked into a motion, we could find that information and come back with an order to affect that if the board is so interested.
Yeah, but what I'm trying to get at is, before I want to vote yes or no on this, I'd like, if the motion is to forgive the lien, I'd like to know how much we're forgiving, because the purpose of the lien is to make it clear to the property owner and any subsequent property owner that because of the neglect to the property and because of the amount of impact that neglect's had on the surrounding community, that we want to get it cleaned up, and we want to get it cleaned up now. And if we can't get it cleaned up now, we want to get a fine on there, get a lien on there, so that eventually the amount of the lien will be so great that no one will buy it. It'll be tax foreclosed. It'll be foreclosed, and then we'll own it, and then we'll fix it up. And that didn't happen in this case. The lien went on, the penalty was on, but no one took any action. Now, that's not the fault of the subsequent buyer. I'm just pointing out that the reason we have a lot of these dilapidated properties around the county is the county hasn't been aggressive about putting liens on. And in my view, and of course, any direction we have, if this motion passes, we'll get a report, from your office on well, what's the financial implications of this decision? And there will be financial implications of taking away money from our effort to deal with distressed properties. And as laudable as it is that someone bought this property with the idea of A, cleaning it up, B, turning it over and selling it, that's great, but the photos do not really show the property's cleaned up, and I'd like to see maybe if the liens can stay on, at least until such time as it's cleaned up. I don't quite understand why we'd be forgiving the lien if no one has cleaned it up. So how much is the lien? You don't know, you'll find out. What's the implication to the program of cleaning up dilapidated properties? And last but not least, why wasn't it cleaned up when the liens were originally placed on the property? Because I get it that Mr. Spencer presents a pretty decent case. Hey, I bought this property and now I find out that I owe a lot of money on the lien and I want to clean it up. But as Mr. Tapia points out, you can usually find out how much liens are on properties through our current property taxation database. So, and then if we're going to do this, if we're going to forgive this lien, I certainly want to know what other liens are out there that we could forgive under similar circumstances where the property owner buys the property, says he wants to clean it up, shows us pictures of the property that's not cleaned up, and we forgive the lien to allow them to clean it up. That's not been the way we've been doing this in the past. We've been piling on the lien until such time as it's cleaned up, not relieving the lien until such time as it's transferred. So, I mean, I'm very sympathetic to the plight of Mr. Spencer. I'm very sympathetic to the commissioner that wants to do the best she can for her constituents, but if we carry this forward and do this in the other cases, well, A, we don't know if it's even legal, but assuming we are getting a green light that at least this motion to direct staff is legal, that's one thing. So that's one thing to get it directed. But keep in mind, we do have a need for these liens, and we should not be waiving them until such time as the property's been cleaned up. So if you can answer some of that now, that'd be great. If not, and if the commissioners want to approve the motion, then we'll get it back when there's a report back or when there's a order back. Is the buyer of this property going to clean it up?
Well, I believe
Yes. Okay.
Mr. Spencer has taken some steps to clean it up. As the staff report mentioned, though, there still is some outstanding work
Why
to
don't
do.
we sell the property then to the people that are going to clean it up? When it gets cleaned up, let's wipe the lien off.
Mr. Tapia is trying to find out if we can determine that initial base principal amount right now. I'm not sure if that's going to happen.
May I speak while he's looking?
Sure.
You ever heard that Harry Belafonte quote, "It's clear as mud, but it covered the ground"? It seems to me, and I'm prepared for other commissioners to tell me I don't quite have this right. Seems to me that we're not talking about forgiving a lien. We're talking about forgiving interest on a lien. It also seems to me that we're also trying to clarify what was the original lien amount. I think Chair Sorensen brings up a good point, which is that, what triggers, we may vote to forgive interest, but what triggers the actual forgiveness, right? And it may be that a clean property triggers that. Now, I personally have been in situations where I couldn't transfer title even though I was involved in a sale until A, B, C, and D occurred. So that notion, that idea really should not preclude a transaction from what I can see, not knowing all the details intimately. Because I appreciate what Pete has said, and yet, and I also think this is an unusual situation. I don't believe we are either setting precedent on the one hand for forgiving all these liens which are set in order to clean up property, or on the other hand, ending the mortgage lending in Lane County. But I do appreciate both those perspectives. So I don't know how to modify the motion, which Heather would have to do, but I don't know how to modify it to factor in all those things. We're not forgiving a lien, we're forgiving interest. How do we find out what that is so the property owner knows, and what triggers the forgiveness? But once we have certainty on all those things, I would imagine a transaction can continue.
So I was going to bring this up a little later, but I do believe some of those questions need to be hashed out in a work session surrounding what we want our policy to be about those things. I can't imagine this being the last time we hear about it, as unique as this particular situation is. But it happens. And so I think those are good points. And I'll bring that up at work session time later in the meeting.
Okay, go ahead.
I'll just point out that the board has requested a work session on our code enforcement process, and that's something staff has had on our work plan for a while and something we're really interested in looking into. And it's tentatively penciled in to begin after the first of the year, an update of our Chapter 5 procedures. So.
Okay, anything further? Yes, Commissioner?
I just want to state real quick, I really support our code enforcement program. And one of the things I've had great frustration with is how little teeth it really has. We throw these liens on a property and we don't have any real position because the first deed of trust really has all the control. One of the reasons why you have escrow when you take out a mortgage is because that first deed of trust person is protecting themselves against a tax lien. They require you to have an escrow account and set aside taxes for 1 year at the opening of a mortgage and continue paying in that estimated tax amount. Because they understand that taxes are one of the few things that can supersede a first deed of trust. But they don't, the mortgage industry doesn't expect anything else to supersede their deed of trust. And that's where I'm a little concerned. There are 6 possible cases of this right now outstanding. Now, we don't know if any of those actually went to a sheriff's sale and whether the same notice that had Lane County listed it as a defendant but was actually dismissed went out. So I don't know if there's actually 6 full cases we might see again. But that's basically what's outstanding out there. This isn't going to be a repetitive thing. And if we can cure the issue of transparency, then there won't be any future cases. That's what I'm looking at. So our liability is these 6 cases, and that's it. And our authority to do this is we're acting in a matter of county concern. We are actually the only body that can waive this lien. Our staff doesn't have authority under our current rules to do so. And we have been asked to waive things before. In fact, I think we actually pulled back on a tax foreclosure on a certain property previously as a board, where it was appealed up to the board level, and we took a property off the tax blocks, basically, and let a family pay their back taxes to hold on to a piece of property for somebody that was not mentally competent at the time. So, we have taken on tax liens, not abatement liens, or I should say administrative liens. So, and nuisance, into our nuisance abatement fund. So I'll support the motion, and what I expect, though, is we'll get back, the motion's actually for staff to prepare an order when you get right down to it. The order will come back to us with that actual amount. So Commissioner Sorensen will know exactly what we're forgiving, because they'll be able to research the original lien, unless you've got an answer for us. Sebastian.
Commissioner Bozovich, I was able to go to Arla Deeds and Records and find the original recorded lien dated September 29th, 2014. The current civil penalty as the date of recording was $21,900.
So that is the principal amount. Great.
And so we don't know what the amount is since then.
For sure you just
Yeah, the 12,000, whatever,
subtract it.
from the 34,000.
Okay. Say, anything further on the motion to direct staff, and I'll let you finish the sentence.
To direct staff to come back with an order to forgive the accumulated interest on the lien for the Butte Street property with the correct accumulated interest calculation.
Okay, so that'll be the motion that we're voting on.
Which is basically option 2 that you've listed.
Correct.
So any further discussion on the motion? Seeing none, we'll go to a vote. All in favor, say aye. Aye. And all opposed, say no. Very good. And my vote explanation is that I would like to make certain that when you bring it back, that you bring back some of the legality of whether we can or cannot do this, and whether or not other lien holders that are out there will, how many of them there are. Commissioner Vosevich asked several of those questions as well, but how many there are, and what authority we have, if any, to require banks to put greater detail in about our liens.
Commissioner Sorensen, point of clarification, you're asking for the previous lien holders that were extinguished through the foreclosure process?
No, I'm saying for the other, I believe it was 6 pending liens that are out there.
Other properties within the last 2 years that I've.
Yeah. Is that a fair statement?
Yeah.
Yeah, okay. So, very good. So thank you so much.
Mr. Chair,
Yes, sir.
well, we're still on the same item. I'm going to make another motion which would supersede the previous passed motion if it passes. I'm going to move to direct staff to prepare a board order authorizing the forgiveness of the lien in whole, 34,778, with a condition that the outstanding or expired building and sanitation permits are obtained prior to the forgiveness of the lien, which is option 3. And the reason that I'm doing that is because I do believe we have extenuating circumstances here where the goodwill buyer had no idea that a lien existed at the time that he made the purchase. Otherwise, he may not have made the purchase. And that based upon the testimony from members of the community, that this is there is a great deal of community benefit in moving forward with the repairs and putting this property into a situation where it fits the neighborhood and it becomes a viable residence. That's the reason I am making that motion.
Second.
Okay. And, Commissioner Farr, do you want to speak to your motion?
I just did. I believe, once again, the extenuating circumstances that the buyer, who was acting on short notice, did not know and had that the lien the lien for $35,000 existed, and very likely would not have made the purchase had he known that. And an addition is that the the testimony from the members of the community that this is of tremendous public benefit to the community of Creswell and therefore Lane County. That it is a set of circumstances that would that is peculiar and would not typically exist.
Okay, any further discussion?
Yeah. Since we're kind of rolling the dice here, so I see in the options that were given us, we are not even considering number 1, which was take no action. We have one motion to relieve all interest, either having been or future to be accumulated. And then we have Commissioner Farr's, which is, I think, relates to more item 3 and 4. So in discussion, I'm going to throw another option out there. What about a middle path being waiving the principal amount of 21.9, but letting the interest accrue as an incentive to pay it, and and allow. It's just a consideration, because right now I don't believe in all or nothing, and I'm just trying to find a middle path, which is why I supported Heather's original motion.
Further discussion on Commissioner Farr's motion? Commissioner Bug?
You know, I thought about making that motion initially because of the work that I know that Mr. Spencer has done. However, when we know the calculation, and that's in our charter, I find that one a hard leap to move forward from. If that had been different, I probably would have made the initial motion. I think we really need to come back in January and talk about parameters ultimately as to why and how we do this. But since it is already codified in the language that we have, I felt like the original motion that I made was fair to both what the county states as their policy, as well as what we know this community member has done for the betterment of Crestwell.
Okay, further discussion on the motion?
Am I allowed to ask a question?
Sure.
Am I allowed to ask a question of Mr. Spencer?
Yes.
Sir, you can see how much discussion this has engendered. My question is, if we pushed discussion forward rather than, I'm just thinking selfishly of my vote, and took action at our next meeting, which is 3 weeks away, would that cause distress to what you're trying to do?
Why don't you come up to the microphone, sir, so we can all hear you, and
And thank you, sir.
That's a good question. I've already delayed the sale only because of this. We've already, by taking people out of the house, the original problem of the septic tank is obviously non-existent. I filled in the empty septic tank when I cleaned out all the blackberries, so that has no septic tank. It is not habitable. The people that have agreed to buy it will either tear it down or they will fix it, and they said in their letter that they will be asking the city to annex it, and they will get all their permits through the city and everything there as it would be after it's annexed. I don't mind paying right away. I felt that it was wrong for me to pay for abatement for the county as well as myself. It was a justice issue for me that made me wait partially as well. I may lose money, but that's something I can handle. But a fairness thing really bothered me. But the fact is that there's no doubt whether or not it'll be fixed up. I don't care what you put on your requirements, that it has to be brought into the city or inspected or anything. No issue from me. Does that answer?
Would it be an issue for your sale? If
They've waited since February. They were willing to come in and tell what they wanted to do this
Right.
morning. He's been in the community since he went to grade school there, and he's a viable businessman there. I do not believe that will affect the sale.
Thank you, sir, and thank you for being a part of this with us.
Thank you.
okay, anything further?
I like my option.
A question, Commissioner Bernie, are you suggesting to table this motion? for
I apologize.
On December 3rd?
I apologize, Commissioner. This is what I'm struggling with. I'm struggling with, this is obviously a good thing that Mr. Spencer did. It's at least alerted me to some of the transparency issues so that these kinds of things don't occur again, which we will work on. And I was just looking for a way without forgiving everything to forgive most of it. And so I was honestly hoping that Sebastian would tell us, oh, there was only about $11,000 on the original lien, but that's not what he shared with us. And that's why I'm looking, I was honestly serious about letting the interest on the lien ride, right? Because we're just looking at the amount of money, and forgiving the original lien because that would be less than the 21,900. So that's all. I'm just grappling with this. And right now, we only have 2 choices to vote on, not a third.
You could amend my motion to say 50% of the principal amount.
Mr. Chair?
Yes?
I'm going to amend Commissioner Farr's motion to forgive the interest and to reset principal at $15,000.
To direct staff to bring back.
Forgive me,
Yep.
what he said.
Which I would take as a friendly.
Thank you, sir.
Second,
Okay, so
If-
why
if
don't we
you're
just
okay with
assume that's the motion? Is that okay?
if the second agrees.
Yeah, I'll agree, yeah. I was
So,
going to second his amended. so-
Commissioner Farr, do you want to restate the motion?
So that would make the motion to be, direct staff to prepare a board order authorizing the forgiveness of the lien of 50% of the principal amount of the lien.
I think he just said it as a dollar number, 15,000.
15,000.
15,000, okay, 15,000 is good.
Little bit.
With a condition that the outstanding or expired building and sanitation permits are obtained prior to the forgiveness of the lien. So forgiveness of the lien in the amount of 15,000.
Well, no,
Excuse me.
in the amount to reduce to 15.
Reduced to 15,000, with a condition that the outstanding, the rest of the language in option 3.
Okay, so it's been moved by Commissioner Farr, seconded by Commissioner Bozievich, and that motion is pending before the board. Commissioner Buck.
I am unclear about that motion.
Right.
Because it did not address the accumulated interest portion of the previous motion, so it almost seemed like it was, I'm sorry, I just wasn't clear. I'd like to get it restated if possible.
Direct staff to prepare a board authorization reducing the amount owed to 15,000 with the condition that the outstanding or expired building and sanitation permits are obtained prior to the forgiveness of the lien. So reduce from 34,778 to 15,000, which would include all of the interest and part of the principal.
Thank you.
Okay. Anything further? Are we ready to vote? All those in favor, please say aye.
Aye.
Opposed, say no. Motion carries. So the motion is adopted. So now you have 2 adopted motions. Plenty of things to do. Okay?
The second.
Yes, sir.
I'd just like to point out one piece on the need for transparency or clarity. Mr. Tapia was able to find out that with the sheriff's auction sale, the sale must occur at least once a week for the 4 weeks, consecutive weeks prior to the sale. So advertisement for one of these sales actually happens for a month preceding the actual sale.
Okay.
That's what I said.
Thank you. Okay, this item has been concluded. We have held our discussion. And a note is coming up here.
I thought it was for you.
And the city needs the timer for the city council meeting. Well, it's being evacuated at this moment. Okay, thanks. Okay, we're done. Thank you very much, folks, Mr. Miller, Mr. Tapia, and others involved in our last item. At 3:30, approximately 15 minutes from now, we're going to be going on to item 11A. And Mr. Dingle, are you here on county administration, or county council announcements, item 6A?
I am.
Very good. Let's do 6A right now.
I thought that we would do this. Mr. Mokorhysky pointed out we have a 3:30, you have a 3:30. So I thought we'd do this, and my announcement might pertain to your agenda team request. The first thing I'd remind the board is that we do have an executive session, which should be around 4-ish this afternoon on Senate Bill 24. The other thing is I sent out this morning, I know that you'd received some material from Mr. Dickinson. I think I sent the board an email regarding the request that he made. Well, I sent it out actually before he made the request because I think my request was before he appeared in public comment. So I just wanted to point that out. In my opinion, that obviates the need for another hearing on, or another discussion on the aerial spray thing. It's pretty clear. But I just wanted to point that out before you made assignments. And that's really all the announcements I have.
Could you repeat what you just said? Because I was listening carefully, but I didn't quite understand what you were saying.
So the reason it got garbled is, at some point in the past, before today, Mr. Dixon, I believe, sent all of you a new proposed aerial spray ordinance. And I think he dropped it off at my office. This morning, prior to him, and then he made a request in public comment that you do at Agenda Team, that you schedule something with that. Prior to him appearing, I had sent you an email this morning that pointed out that the two statutes that preempt the action that is purported to be taken by that measure specifically prohibit the adoption of an ordinance. Not just, it says adoption and enforcement or other regulations regarding it. So what I put in the email was that it doesn't change anything. This is different than the situation that he described with Measure 47. And in my opinion, it doesn't make any sense to have another session on the aerial spray measure. I just sent that, I didn't know he was going to actually appear and do that because I sent my email before he did, but
Okay.
we kind of came together, and the reason I'm saying it now is I know you're going to talk about a future assignment, so.
Very good. Thank you. Anything else in the way of announcements that you have on item 6A?
No.
Okay, very good. I have questions about your announcements. Commissioner Burney.
Mr. Dingle, while you're here, I just want clarification, because my sense, and I truly do not know, but my sense was he just wanted us to be accountable and to vote, on whether we were going to refer that. In a world where your advice doesn't exist, that was my understanding. He just wanted us to stand up and be accountable. Was that your sense, or was it your sense different?
Well, I didn't know exactly what he was doing, but I wanted to make sure. All I saw, my email was written in response to him dropping off the proposed new ordinance and the email that accompanied it, more than what, I just noted, I didn't hear everything that he said. I just heard him say, I'm making a request of the Agenda Team. So, and I know you're going to start doing this right now, so that's why I came down.
Thank you.
Okay, so we have about 12 minutes before our session at 3:30. Looking down on our list of things, Mr. Mokrzycki, do you have some guidance on what we can do next?
I think you could finish your announcements and do agenda team requests and work session requests, and we'll probably be close to 3:30 by then.
So we finished item 13A, our announcements. Item 13B, any agenda team requests? I have one, and I'd like to follow up on, and I'm not quite sure how to phrase this, so I'm open to having the way we phrase it, but I'd like to get a follow-up to the discussion we had with you during your announcements to make it more formal, and wonder if we could get a report back on the feasibility of involving the public whose properties are affected by homeless people who are camping in medians, or people who want to volunteer to help the homeless, or people who are homeless and who want access to services, whether we could get that on our website or not, whether we could get the information that Commissioner Bozovich and Bernie and I were asking about in terms of the volunteer sites, maybe the extent of government funding for those sites, whether they're staffed by professionals, whether they're staffed by volunteers, kind of get a flavor for, from the consumer point of view, from the homeless person or the neighbor who has homeless people along their street, or business owner, or someone that wants to volunteer and help these nonprofit groups. And so that was really my follow-up to that. to make that more formal.
So that would be a report from staff on an update of services available for unhoused
And
individuals.
how we
as well as
recruit
resources.
volunteers, how, I believe Commissioner Bozievich had the suggestion that what's a list of the sites, when are they open, what are, if they're staffed by government employees or by nonprofit employees, or whether they're truly volunteer and depend upon the time of the volunteers and whether there's enough of them and what criteria they use to open these facilities.
So much of that information exists, and you just would like a staff report on.
And also the vitality of how easy it is to obtain it. Like, for example, I'll just give you an example. I drive from my house to this building to work, and I see homeless people. Who do I report that to other than the police? Who do I report it to? Is there a way for me to get on a website that says, hey, by the way, there's a whole bunch of people camping on 4th Street, 4th Avenue in Eugene, over west of the grain millers, and what can you do about it? Right now, all I could do is call the police. And what my constituents have done is they've called me, and I've gone over there to talk to the people and find out if they're moving or not. So I want to be clear, though, this is a request I think the board should make, and I want to make sure that there are 3 commissioners that think this is worthwhile.
Still a little fuzzy on the exact request.
Yeah, what is the request?
We're all fuzzy.
Okay?
Yeah.
I'll take a second crack at this. We'd like to have a report back from staff that covers the extent to which there are resources for homeless people and whether those resources are paid for by volunteers, by nonprofit groups, or by government, and an inventory of those sites.
We could do a report on this document.
I wonder if maybe the way we could start is to forward commissioners information that exists already online. Have you review that? And then, I mean, we certainly can bring a report to the board on homeless services. I think you've had a couple of those reports on the human services system, on the TAC report, on various services that are available. I'm hearing sort of a broad, you're interested in sort of all the services that are available in the community.
I'm actually, just on my own, I'm more interested, I think that the reports are out there. I'm not really asking for a report. I'm asking for whether or not there can be a range of actions on how to involve the people concerned about the homeless problem on a case-by-case, individual-by-individual basis, whether or not volunteers have a portal in which they can show that they're interested and how they would sign up, and last but not least, how homeless people can access this by means of an online system and the expenses associated with that, whether that's being provided by some people, maybe by others, I don't know. I just feel like there's more we can do in an interactive way with the different parts of the homeless system. Not more reports, but more action. Sir.
I'm just going to get involved in this discussion a little. I think I apologize, but I have not seen the pages on our website that Commissioner Farr mentioned. So for me, at least, as a baseline, I just request, send me the link to that and let me study that. I think that probably some commissioners don't need that, but I do. Then I think, Mr. Chair, if we have ideas for maybe a work session down the road, but ideas for how to make that more interactive and how to make that more robust, we do it there. And that way, that's the only way I would amend what you're saying or suggest.
And just a clarification, when you look at this report, you'll find an out-of-date and incomplete report. And so a part of the request would be, how do we bring this report to a point where it is more current, even though it's not a dashboard, as suggested earlier, where it's dynamically current on a daily basis. And then it would help us to identify what may be missing from this particular list that we do supply online.
And if I may, that would be a conversation then that might time well with your hiring of that strategic initiatives manager.
And it would be fun, because we'd be able to identify a course of action, rather than throw our hands up in the air, which is what we've been doing for all the years that I remember.
Does that feel like it responds to?
That's fine. I just would like to know where to send these people, so. Okay, any other requests? Yes.
I want to follow up on the Oregon Rain conversation earlier when Ms. Cummings was talking about how we can help support, capital investiture in our local businesses, and she specifically stated the program Local Stake. I think I said that right. I don't know it very well at all. But it would be great if we could have staff, namely Austin Ramirez, come back to us with maybe an action item on that particular issue. She had specifically asked for a letter of support, but I would like, I think it would be worthwhile for us to ask Austin if he could come back with a report on how we could, if that's the right way to support it, or if there's a better way to support either that program or capital investment, angel investor programs for the county.
You're talking about state funding for Oregon Rain?
No, not necessarily. I mean, it could be any kind of capital investment for small businesses through the Oregon Rain program, but she specifically talked about.
Oh, the $4.3 million in capital funds.
Part of, I'm sure that's part of it. It's just a way for, I think, everyday folks to be able to participate, being an investor in small businesses in Lane County.
Okay, are there three commissioners that want to agree with that? You can raise your left hand. So there are three commissioners.
Yeah.
Anything further from commissioners on agenda team requests or work session requests?
Just to follow up on that, this morning Ms. Cummins also suggested that we prepare an email to Leah Horner regarding state support of the rural community. That's exactly what you're saying there. Okay, so that's that email. And that would be a part of it, would be a message to Leah Horner. Right on, okay.
Okay, any other agenda team requests or work session requests? Very good. So at this time, I will call up our folks to get ready for our 3:30 time certain and get all together. Sounds like Ms. Williams is already jumping into place, getting the high-tech machinery ready. So at this time, I'll call up item 11A. This is our discussion and report back on the coordinated facility planning. With us to discuss this today is Steve Mokrzycki, Lane County Administrator, Mike Penwell, Capital Projects Manager for Lane County, and Judy Williams, Strategy and Integration Manager. We set this up for a 30-minute presentation to have 15 minutes from preparation and presentation, and then 15 minutes for the board. Welcome to all of you, and I'll ask Mr. Mokrzycki to start this off.
Thank you, Mr. Chair. So we have a relatively brief presentation, and this is, I'll start by saying we're not asking for action today from the board. This is a report back to answer some of the questions that you had for us back in July. I think on July 30th, we came to the board to talk about the need for additional space for a developmental disability services operation that continues to expand with additional state funding and demands from clients in our community. Important to be reminded that we have an incredible developmental disability services staff in Lane County. Throughout Oregon, we provide what is arguably a nationwide leading level of service to individuals and families with developmental disabilities. And our staff here in Lane County do an incredible job, and they continue to grow. And we really have outgrown our space here in the Public Services Building. So in July, we reported to you on that and talked about some options for you to consider, and you asked some additional questions for us about coordination of facility planning. And so we've gone and over the last several months worked with a team of individuals in our organization to really identify highest and best use and respond to some of those questions. So you can go to the next slide, Judy. We're just today going to talk about a little bit of that timeline, the effort that we have gone through to analyze the facility needs in various places and determine the best options for the board and for our organization, and then we'll ask for your questions and comments.
Thank you, Steve. So I'll just briefly walk through the next few slides and then turn it over to Mike. So as Steve was mentioning, we've done a great job. We have a great team in our capital projects team. We've done great work when we've really tried to focus in on what are the aspects that a program or department needs when they're looking at expanding or relocating or renovating. And what good questions really did come up on that July 30th discussion when we were talking about the options for developmental disabilities services. And so those were great questions that really just brought to light the need to look at this at a more holistic level. And so we created that mechanism to really have those conversations across departments and look at what we're doing. So as Steve was saying, the timeline, we really got together after that original late summer discussion, got a team together led by county administration and worked with all departments to really look at what are some of the projects that they have in the pipeline, what are upcoming issues or concerns, and then how do we go about planning for those. We have this discussion today at the board, as Steve mentioned. It's not, we're not looking for direction, but just trying to give you an update on the work that we're doing as it may help you with future conversations. And then we'll continue with this coordinated facility planning effort throughout. And just a reminder as we go back to the July 30th conversations that really spearheaded this conversation was looking at those three options for developmental disability services. One of those was to renovate the space that they are already in the public service building, in this building. The second one was renovate the existing armory on the MLK campus. And the third option was to build a new building replace the armory at MLK campus. And I would say, generally speaking, the board was not a fan of option number 2, but was kind of cautiously supportive of number 3, but just had several questions. And just some of those themes of the questions that came up during that board discussion were really, what are some of the impacts down the road? So in this building, for instance, who might go into that space if DDS were to relocate? What are some of the impacts to the conversations that we're having and the planning efforts that we're having with Justice Center? Some other questions came up, but those were the majority of the themes, and we'll go back to these and answer some of those questions for you in a few minutes. So as we got together, our planning group to really look at this holistic way that we can try and make the best plan for facilities for the county in the future, we got together and created this purpose statement as a body. And so that is to invest in the highest and best use for each county facility, to understand operational needs, timing, strategy, and best use of available funding. We also need to have a functional plan that also allows us to remain agile as needs change and circumstances arise. And then I'll turn it over to Mike to talk about the principles.
Thank you. Well, as we started looking into this, it became clear to us that there's a number of moving parts throughout the county as we're trying to put these things into place. There's been a lot of things talked about over the years that I've heard about anecdotally since I've arrived. And so we sat down and got those out on the table, and we really realized that we need some principles to underlie our planning, because the context sets the stage for the content that emerges from it. And so those principles focus primarily on providing for integration of services for efficient coordinated delivery, providing for workspaces that enhance recruitment and retention efforts in our workforce, use an equity lens to provide for fair and equitable delivery of services, and take the long view in terms of emerging trends and changes while also providing the context to respond to emerging opportunities as they arise. So I think the county has done that in pieces and parts, but we want to use that those principles to undergird decisions moving forward, because things change over time, but if the principles are in place, then we can make sound decisions out of that. And
I do.
So we also wanted, I was going to walk through these, right? We wanted to share with the board, over several years now, we've gone through a process of identifying properties, acquiring properties and buildings, renovating or building new facilities with an eye towards co-location and coordination of services. So we'll flip through a few pictures, but this shows you our public health and primary care facility, the Charnleton building, as we oftentimes call it. In this building, we have primary care. One of our FQHCs operates out of here. Our public health operations operate out of the Charnleton building, which includes environmental health and our WIC program. We have veteran services and Health and Human Services Administration. So in this facility, as customers and clients are coming to access those services, you really have a coordinated set of like services that are not only for the benefit of the clients who are coming to access those services, but also for the staff that are engaging and supporting each other in those areas. Here you see the MLK campus, an aerial view, and on the far left you can see our behavioral health facility and sort of the grassy area to the bottom of that we will be at later this week for the official groundbreaking of the permanent supportive housing facility. And as you go across that campus, this really, you understand, is our social service campus, where we're serving individuals with mental health and behavioral health services. We have a high school here. We're serving youth who are going through the criminal justice facility, who are struggling with substance abuse issues or other challenges. We have Kids First and Stepping Stone and various social services that are providing a safety net for individuals and families in need in our community. And of course, this is where we've talked about the opportunities that exist for our developmental disabilities operation in the future to be co-located with other like services in the community. Here you have the Customer Service Center out on Delta Highway. This was renovated, what was the year?
7 or 8 years ago now, I think.
Yeah, 2011, 2012 timeframe. And here you have, this was very intentional, a lot of planning work that went into this by the county to identify an opportunity to have a one-stop shop for customers that were accessing building permits and planning and other services like county engineering and animal services and parks. All of our public works functions operate at this campus out of the Delta facility. And then finally, the Public Services Building is our general government facility that houses assessment and taxation and deeds and records and technology services and financial services, county administration of the Board of Commissioners, and then the adjacency to the current courthouse with the public safety and justice systems there. And so you see that as we talk about developmental disabilities, and one of the challenges that we face is access to those services for those customers, the lack of sort of coordination with other like services in this building that really is focused in a downtown urban setting at providing general services to Lane County residents.
So wanted to address the questions that came out of the July 30th meeting more directly, starting with the impacts to the public service building. We're in the planning stage for the tech services remodel, which would consolidate all of the tech services functions on the ground floor on the north side of the corridor. The desire would be to get developmental disabilities out of the basement into a more appropriate location, which would then make room for consolidation of the county clerk functions by planning for bringing elections over. There's a few logistical issues to solve there with delivery of ballots and that sort of thing. But it's long been a goal of the county clerk to consolidate all the functions under one roof. The city of Eugene is on a timeline to replace the city hall that's still at least 2.5 or 3 years out, so that's obviously not going to be immediately available. And I think it's important to talk about the context of our continued Justice Center planning and being able to preserve some options for at least exploring moving some of the functions out of that into the public service building and see if there's anything that makes sense along those lines. Long term, as Steve said, preserving the public service building for general government services. We recently remodeled the upper floor in county admin, and it's full to the max already. We're already looking to add a position on homelessness, and HR, and the human resources and the county attorney's office is full to capacity. So we've done a great job of getting to a stable budget, but now we have to preserve opportunities over the future to put people that if we add over time and grow along with the community to add those general government services. And then the courthouse itself, assuming we're able to come up with a plan to move out of that, that's going to be a whole nother discussion. That's basically a gut and remodel project. Many of the issues that make it an inappropriate courthouse, aging systems, no seismic upgrading, various problems that the building has would all have to be addressed for any function, and that's pretty much a gut and remodel. So whether it remains as a county facility or becomes an asset that we use to pay for other things, whether we partner with the city of Eugene, I think that'll be a discussion further down the road, but is not something that's going to immediately contribute, I think, to our space issues.
So just in summary, and I'm actually really excited about this conversation, that you had a discussion earlier today where the board authorized the acquisition of a property to move parole and probation that has been years and years in the making. That is really, it's not only identifying a better property where staff can feel more comfortable, it's really about enhancing the efficiency and effectiveness of the services that we provide by, in that case, for parole and probation, identifying a location that is appropriate for that operation and providing the space necessary for them to be the best that they can be with the limited resources that they have available, as well as the adjacency in that case to other like services like sponsors and other service providers, including St. Vincent de Paul in the area. In this case, again, we're talking about creating an opportunity for developmental disability services to expand on a campus with like services, to increase and enhance the accessibility of those services for our clients, to increase the quality of services that can be provided because of the space that will then be available, the privacy of meeting space, the efficiency with coordination of other services in that area, and then the benefits that we gain by opening up space in this building, both in terms of the continued consolidation of other functions like elections in the building and the flexibility that it provides us as we continue to plan for the best proposal for a new Justice Center as possible, which you saw noted in the staff report. So coordination and efficiency of services, access for clients and staff, meeting the space and expansion needs of our operations, and then creating flexibility for those space needs are all critical components here. I know one of the key questions that I've had, and I know the board is going to have, is about funding. Well, how are we going to pay for this? We will be coming back to you on December 10th with a more detailed discussion on our recommendations for the developmental disabilities. So I don't want to stop you from asking questions about that, but today was really to try to answer some of those broader facility coordination questions, and then allow us, when we come back in December, to have a more detailed conversation about both the financing and operational and construction plans for developmental disabilities. I will just say on the funding portion that another benefit that we see that allows us to even consider a proposal to move developmental disabilities out to the MLK campus is the opportunity to leverage 2/3 of the cost of that facility from state funds. So we'll talk more about that on December 10th. But I wanted to just put that on the table as well. So I think I will, do we get it all for the most part? I'll stop there, and then we're prepared to answer questions that you may have.
Okay, very good. Well, wonderful. This really advances this a lot. Thank you so much. Do any commissioners want to be recognized to ask the first question? Go ahead.
So I don't really have a question. I just want to say thank you. I was kind of the one that pushed this issue when you guys were talking about moving DD over to the Surbu campus there on MLK. And part of it was that question in my mind was, there's going to be space opening up here, you know, and if we move DD, that's even more space. You know, can we even, you know, are we going to end up with empty space here and paying for a building there? And so you kind of went back and re-answered some of those questions for me, and I really appreciate that, because now I can look at that and say, yes, it makes sense to go through the cost of building a new building and relocating DD over there, because we do have use for that space here. You know, that was part of my question, you know, because we do have a lot of facilities, you know, and a lot of space, office space that we own and run, and at the same time, we're still renting space. You know, we still have part of our DA's office in rented office space. So, you know, that's, you know, hearing that I'm renting space in one place and we're going to build new space and we're going to open up empty space, I just, you want to know that we're doing that, you know, kind of reminds me of that game you used to play with kids that had the tiles where you had to try and get the things in either alphabetical or numerical order, and you had to slide tiles around to get them in the right place. We're playing that little tile game right now. And I just want to know if we were looking 4 or 5 moves ahead, or we were just looking at the first tile move. And it sounds like we're actually about 10 tiles ahead, and that's where I want to be. You know, as you guys are looking down the road to how to get to that, you know, put that whole thing into order. And I really think this was an important step to kind of back up and do, and I really just want to appreciate staff for doing so. I read the staff report. It all made sense, and I appreciate the effort.
Any other commissioners want to ask any questions or otherwise participate in the discussion? Commissioner Farr.
Thank you, and I applaud everybody's effort in making, you said the best and highest use. I love that term, that we're utilizing for the long run, the best and highest use. And remind you that all along I've always talked about the best and highest current use. And if we have vacant facilities, then it's not the best and highest use. And it's a broken record when I talk about this. I'm looking back on October 24th, 2018, when we had a large group of people that toured the Armory in preparation for the winter coming ahead, and discussed how we could use it that winter. And there were all kinds of ways that we could use it that winter, other than we ran into some obstacles along the way. You know, so it was one of the things that we do every year. We seem to try to find new ways to address winter strategies, and we do address more and more every single year. A year ago, in 2018, we tried to address using the Armory, and it just did not work out. There were conditions, none that I would like to have seen, but conditions that certainly did exist. So as we look for the best and highest long-term use, I'm always excited about the fact that we're looking for the best and highest use tonight. if we can use it tonight, as we did with the Willow Pavilion, for instance, last week, and as we are doing with the Armory for a special purpose in packaging boxes for Thanksgiving, for instance. So finding ways to use our facilities while not interfering with a longer-term plan is always something that I'm excited and would like to see more, be as aggressive as possible in doing so. So, Ms. Mokarasi, thank you. You bore with me on that day in October, and there were a bunch of us out there at the Armory, and the director of St. Vincent de Paul was there. He was pretty excited, as was Roxanne O'Brien was pretty excited, and I was pretty excited. And I think it kind of set the wheels in motion in a lot of people's minds, thinking, hey, we can use this building. It doesn't have to, or this facility, this space. And I think at that point in time is when we started really aggressively looking at how can we use all of our facilities. So well done. We're moving in the right direction. But in the meantime, let's always remember what's the best and highest use tonight, if we can possibly use it tonight. Thanks.
Any other questions, comments? Commissioner Bernie?
Plus one. Yeah, this is a refreshing criteria. I always look at the worst and lowest use. I'm sorry, it's just like, obviously. So forgive me, I also was asking some of those questions, and so forgive me if I ask some more. DDS, how many square feet do they have and how many square feet do they need? And if it's in here, which it probably is, I apologize, I don't have it.
Yeah, it's not in here. I have those figures, but not on me. Currently, it's 17,000-ish, and the need is for about 25,000.
But wait, there's more.
I saw Steve go, come on.
Well, we've moved into some additional space because right. So we, I don't remember. I'm sorry. I'm Carla Tazimal, the Manager for Developmental Disability Services. Thank you. So just to answer the prior question, we literally ran out of space. We had people sitting in the copy room, and so we had to start moving into some additional space. So we have taken over a little bit of an additional area already that wasn't finished. So we're currently occupying about 16,000 square feet, and we're looking at needing about 24,000 square feet long term.
Thank you very much. And you know, I actually asked more questions, and forgive me, Steve, I know you want to withhold this, but 2/3 of the cost of a DDS building would be offset by state money. I mean, that to me would eliminate 18 of my questions. Could you just give me a little info on that?
Sure. So 2/3 of the funding would come from state funding through the opportunity to bill for services. We do have reserves right now between us and I believe H&HS. We'd be looking at putting down, it's approximately $5 million, and then we would be looking at a $5 million, well, I think it would be a $10 million bond, or the county putting in $5 million of that, and DDS over time paying towards the bond through this. The ability to add staff over time allows us to bill more, which allows us to pay back that bond.
So the revenue stream would pay back the bond?
Correct, and we have reserves as well.
Oh, okay. Well then, hey, we would not need to go out for a bond to refer it to a public vote?
No. We would likely issue a bond backed by dedicated sources.
Right,
That makes sense?
right,
Yes,
which
but
makes
not a-
sense.
No, it would not be a public vote.
Thank you very much.
And just to say that developmental disabilities is one of our services that we provide that is 100% supported by state funding. The reimbursement for services through state funding, and does not receive any general fund resources.
Thank you very much. And the only other comment I agree, it's great to see this. It makes eminent sense. And every time I dig in more of the finances, it makes sense. Until I do, though, I don't understand. I would also, I look forward to, one, having a courthouse bond that reflects more of the community's input passing, and having the question before us being, what do we do with that space? And as we look at that, this is like way into the future, Mike, but as we look at that, and you talk about aging systems and seismic retrofits and what have you, let me just share that apprenticeship programs and all the building trades that will bring in apprentices if that occurs. I don't know if I'm pointing in the right direction, but I'm pointing where the parking lot is now in my head. And, and that's an opportunity. That court building is an opportunity to train apprentices in all the building trades and get that work done at very little cost to the county. And I just want to share that with you in the event that we get to deal with it. But I agree with Jay. And now that I understand how we would finance a DDS building, I feel a lot better about all that. My only last question is, how many square feet does the city of Eugene lease from the county?
10,000.
And that lease expires November 2020, if I recall the last time I asked that question.
Oh, we just looked that up recently, and I've.
But it's a year-to-year, right? Yeah, it can be re-upped year-to-year.
Oh, they have the ability to do that? Well, so much for that leverage. Okay, thank you very much.
Okay, any other questions or comments?
I'll just
Okay.
ask a question which you may already be planning when you come back in December. We have a, fair number of capital construction remodels in process, and it would be great to see the timeline of all those and how they all go together. And sounds like you should already have this, I imagine, but it'd be great to have that as part of the feedback when you come back.
Yeah, and Mr. Chair and Commissioner, I think that's not only a valid, but a good request. It's one of those things that can be oftentimes confusing for folks when they look at this and go, wow, there are a lot of projects that are acquisitions and construction projects happening, but really important to break down both the timing and sequencing as well as the funding sources of those. Obviously, parole and probation has a completely different set of resources that it accesses than developmental disabilities, than the Medicaid-assisted treatment facility that we're looking at on West 11th. So we certainly can do that on the 10th, is maybe have a chart of each of those, what those look like and kind of the timing. And so that, unless you'd like to hear about that as part of a different presentation.
If there's time, that seems
Okay.
seems the right time.
Okay, thank you so much. It's great, and we're really looking forward to the December 10 session and what we can do for people in our community with disabilities, developmental disabilities in particular. Really great, and thanks for putting all the hard work in on this, and we'll look forward to the next session.
Thank you.
Thank you. Okay, we are now ready to either do our review of assignments or do our executive session. What is your preference, Mr. Mokryski?
I'm happy to do assignments, and then you can go into exec session. I don't believe there's a need to come out of exec session.
Okay, there's no executive session?
There is, I said, I don't think there's a need to come out of executive.
Oh, okay, yeah. So let's go ahead with item 14, the review of assignments.
So Commissioner Bozovich, well, actually, I'm going to combine that because Commissioner Bozovich had originally asked for our shelter capacity, but then Commissioner Burney had asked to send an email. So I'm just going to say one assignment is Commissioner Burney and Bozovich had asked for a link to the information that exists on our website about various homeless services, shelter services on our human services site. So we'll send that out to the board for your review. And then Commissioner Buck had asked for a staff report back on the need for identifying additional capital funds for small business, rural entrepreneurs, and how the county can be of assistance.
So
And then I had the one on, there wasn't a board order, the action that the board took on 12A, but Ms. Jones said she had that and it didn't need to be reiterated as an assignment, so.
Yes,
So
we had
just
two
on-
motions passed there.
Yeah, on the assignment around homeless, one, I already sent the board the link to what Commissioner Farr, the material Commissioner Farr brought in. And so the only thing really missing was the question about what's the capacity of the warming center and some of the other things that aren't listed on that.
Egan in the other pieces, yeah.
Yeah, Egan and things like the various rest stops and other pieces of temporary shelter that really aren't listed in that.
Right. That list is, I would say, maybe half to 2/3 complete.
Yeah.
There's a lot of other.
And that was kind of part of my point, yeah.
Yeah.
But it's a good starting point.
Right,
But community-supported shelters, for instance, is not on there too. so-
right. The Dusk to Dawn is.
I would say if you have any information on where people can go to for resources when they have conflicts in their neighborhood about homeless people, or if they want to volunteer to help homeless people, if there's any way that we can provide that information.
Okay. We will follow up with the commissioners in an email on that as well.
Okay, so any commissioners want to clarify or anything on the review of assignments? Sounds like we're done with that. Okay, and then are we going to be moving upstairs for the executive session?
Correct.
Okay, so at this time, we'll go to item number 15, executive session. At this time, I'll read the notice, and we'll be going upstairs for our executive session. The Board of Commissioners will now meet in executive session to consult with counsel regarding the rights and duties of a public body with regard to current litigation or litigation likely to be filed. This executive session is held pursuant to RS 192.6602H, which allows the Board of Commissioners to meet in executive session for the purposes listed. Representatives of the news media and designated staff shall be allowed to attend the executive session. All other members of the audience are asked to leave the room. Representatives of the news media are specifically directed not to report on any of the deliberations during the executive session, except to state the general subject of the session as previously announced. No decision may be made in executive session. We reserve the right to come back out into public session should the need arise. So at this time, we'll be in recess for 5 minutes during our executive session. We'll reconvene our executive session at approximately 5 minutes from now.